panel can mute, that would be great. So everyone should be muted, both in terms of the camera and the speaker. Thanks so much. Perfect. So thanks for waiting. Welcome again to the ACICA45 webinar on how to start an arbitration. This is part of an ACICA45 series on the life cycle of an arbitration, where we're going to walk through the arbitration process from the beginning of the arbitration to the conclusion of the proceedings, and then also to the enforcement stage of the arbitration award. My name is Guillermo Garcia-Perrote. I'm a senior associate at Herbert Smith Freehills here in Sydney, specializing in international arbitration, and it's my pleasure to host today's webinar. We have a great panel to discuss the start of an arbitration. We have Gitanjali Bajaj from DLA Piper, Robert Tang from Clifford Chance, and Deborah Tomkinson from ACICA. I'll introduce them in a minute, but before I do that, let me explain how we're going to structure the webinar. We're going to have three main sections to the webinar. The first section is going to be the form and content of pleadings. The second section is going to be the appointment of arbitrators. And then finally, the third session is going to be on challenge to arbitrators. We're going to have a short, very brief Q&A at the end. So we'll be able to go over a few of your questions. And now let me introduce the great panel that we have today. Gitanjali Bajaj is a partner at DLA Piper. She co-heads DLA Piper's international arbitration practice for Asia Pacific. She specializes in international commercial arbitration with a sector focus on infrastructure, construction, oil and gas, transport, power, and energy. Gitanjali has represented clients in arbitration under various rules internationally, especially in disputes across Asia Pacific and the Middle East. And she also practices in public international law and has acted on high-profile cases recently. Then we have Robert Tang. He's counsel at Clifford Chance, who also specializes in large-scale, high-profile and complex international arbitrations. His areas of focus are construction and infrastructure, as well as disputes in the information technology, media, and telecommunications sector. Then finally, we have Deborah Tomkinson from ACICA. She's the ACICA Secretary General. And before joining ACICA, she worked as a senior lawyer in a number of top-tier firms in Australia and UAE, and focusing on commercial dispute resolution in the energy projects and construction infrastructure industries. As Secretary General of ACICA, she leads and manages the center and supervises the administration of arbitration and mediation cases under ACICA rules. So really a fantastic panel to discuss the start of an arbitration today, and we hope you enjoy the session. Without further ado, let's jump in the first topic, form and content of pleadings. And let me start with you, Gitanjali, on how does one refer a dispute to arbitration? And I chose refer because most dispute resolution clauses that provide for arbitration say something to the effect of parties agree to refer any dispute to arbitration. What does this mean, Gitanjali?
Thanks, Guillermo. As you said, dispute resolution clauses generally just simply say parties should refer parties agree to refer their dispute to arbitration. Mostly these clauses then go on to say arbitration under certain rules, unless of course it's provided for an ad hoc arbitration. So when I say rules, they'll probably talk about an arbitral institution like ACICA or SIAC or ICC or HKIAC. So the first port of call for parties, if they want to refer their dispute to arbitration, of course, is to look at the rules that have been noted in their dispute resolution clause. And when they do go to the rules, what one does find is that there's a fair bit of commonality across arbitral institutions in the rules on commencement. So most of the rules provide for commencement of an arbitration by way of notice of arbitration. ICC likes to call it a request for arbitration because it likes to be different, but it's the same thing, a notice or a request for arbitration, which needs to be submitted to the arbitral institution. Now, the rules provide a full guideline on what should the form and content of this notice of arbitration should be. So, and again, fair bit of commonality. Most of the rules will provide for the basic things as that you have a demand that you're referring your dispute to an arbitration, you have the contact details of all of the parties, you refer to the arbitration agreement that you're relying upon, you refer to the underlying contract that the dispute arises from, you provide a brief statement of what your dispute actually is and the relief you seek. And you can also then provide arbitrator. And some rules also, I know that ACICA rules don't specifically say this, but some rules also that require or say that you can provide a comment on the applicable law, the seat and language of the arbitration. So that's generally fairly the form and content. It's quite common across all institutions. But I think one thing people may overlook sometimes is all of these rules also provide that you have to, when submitting this notice, also be submitting your filing fee. And now this notice of arbitration document is basically your date when an arbitration commences, but it requires you to follow the form and have the filing fee. And when people don't realize that your filing fee is late, most institutions will take the date that they received your filing fee to be the date of commencement of arbitration. Why I emphasize this point is, if you look at it from a statute of limitations point, if you are in a situation where your client has left you till the last date to file your notice of arbitration and you're running against the clock, just remember to have your filing fee ready. And my war story on this is I did have a case a couple of years ago where my team had done a great job in having everything ready. And we were ready to file and we realized that our finance department had actually closed for the evening. And so we needed to somehow be able to get the filing fee across. Of course, there were methods such as our credit cards or other international offices, but that's the war story in relation to this.
Right. Thank you so much for that. One of the things we like to do in this first section is to focus on the differences and similarities between arbitration and court proceedings. So based on what you were explaining to us, the request for arbitration or the notice of arbitration, is it similar to the origination process like a summons or a statement of claim in court proceedings, and what are the differences there?
Sure, thanks, Guillermo. So in relation, you can say it's similar to a limited extent in that it is an originating process, i.e. it is your introductory document that commences the arbitration. But I think that's where pretty much the similarity starts. It is the document that commences the arbitration. As I said, the form and content can be quite limited in the sense you can, in terms of how much you provide about your dispute, can be limited to just the basic facts about your dispute. It can be comprehensive if you want it to be. There is usually no requirement to have any documentary evidence to go with it. And when you talk about a statement of claim, the way the arbitration rules generally work is that most of them say that with your request or your notice of arbitration, you may include a statement of claim. So you don't have to, but you may. But in practical circumstances, at least in all of the arbitrations that I have experienced, usually there is a staged approach where you follow a commencement process with this notice of arbitration. 30 days later, the respondents will provide their response. You go through the arbitral appointment. You have your first procedural meeting where you set up your timetable, and then you go through this phase of, for want of a better word, the pleadings, or better put, the written submissions phase in an arbitration.
Thank you so much, Gitanjali. So you talked about the staged approach to arbitration. So what are generally the steps of an arbitration as compared to the steps in court proceedings? And if you can walk through also the typical debate in arbitration dealing with the different type of pleadings, that would be great.
Sure. So as I mentioned, usually commonly you will go through your request or notice of arbitration and response. And once you have a procedural tribunal, you'll go through the written submission phase. it is that latter phase where you can draw comparisons and contrast with a litigation. So there are two ways that phase can work. One, again, this is also better word. I keep saying also better word for pleadings because there is a style of written submissions that you can do, which is more commonly common law jurisdictions and a bit of approach in the sense of the way the stages work, but I have to reiterate that the actual content is quite different from the way you would do it in a court. Although first, you will have you'll have your statement of case, you'll have or statement of claim, you'll have your statement of defense, you'll have reply, rejoinder, disclosure, which is akin to discovery, but it's called disclosure, and then you have your witness and your expert, so lay and expert evidence. Now, this sounds very, I'm sure many people are sitting there going, well, this is exactly how you do it in a court, so what's the difference? Well, the thing about the written phase of an arbitration is it's actually one of the most important processes. It is where you put in all of your case and you make your case for the first time. And it's not always necessary that your arbitration will have an oral hearing in the end. So parties put their blood and soul and everything into this written phase. In terms of the actual content and style, the statement of claim or case, for example, it's a narrative style. You don't generally refer to particulars. You basically put your submissions. It's almost like a cross between as a comparison that you put in your story, what you actually put in your submissions on each and every claim. So it's a much more of a narrative style. Same thing with the defense. You don't go with the, you look at a court defense and it's like admit, deny, do not admit. You don't have that. It's a narrative style. It's factual. You make your submissions. So that's on the pleading style phase stage. And on the memorial side, the content is quite similar. The basic difference between the two styles is the memorial style comes from the civil law jurisdiction. As everybody knows, arbitration is cross-cultural, so all of this is borrowed from different jurisdictions, and it really just depends upon the parties or style available. And you basically have your memorial at the start, which has everything. So you will have your statement of case along with all of your evidence, whether it's your lay evidence or expert evidence. So it's all done in one go. You don't have stages. And then there'll be a counter memorial from the other side, which is also all done in one go. And then there'll be a reply stage. So the basic difference is you're not separating out your evidence and you're actually putting it all together. So that's on the stages. On the age-old debate of what's better, look, I know that common law practitioners have a tendency to prefer the pleading style just because that is what we are used to. I think there are pros and cons in both approaches. So, and ultimately, for me in practice, having done both, for me, it has always depended upon the nature of the case, whether you can do one or the other. So, for example, a memorial style, because you have to prepare up front, while it can be expensive in the front, it actually then plateaus out. You've already built your case. It also requires you to take forensic decisions very early, so you're less likely to have frivolous claims because you're putting it all out there. And one thing I find with the memorial style, for me personally, what really matters is a memorial style. If you're looking for if you're starting a process to gain settlement, a memorial style is actually helpful because you basically show the strength of your case up front so that the other party can see the seriousness of it and perhaps enter into a settlement discussion with you. That said, the pleading style has its advantages of the fact that you're just doing your essentially the main, boiling down the dispute, like the main facts of a dispute will then later help you to have better factual evidence because you've seen what the dispute is actually about, you've seen the documents that have been disclosed to then write your evidence. It really just depends on the case. I'll give you an example of last year running two cases on two completely different styles. One was a more straightforward case in the sense of we all knew what were the facts in dispute, both sides. Both sides knew what was exactly the expert evidence that was needed. Both sides knew who the witnesses were. Basically, when we started that dispute, everybody was pretty much aware of everything that the other side has and what it was. It made more sense for us to do it memorial style and just put all our cards on the table. It was, yes, front-loaded, but it was efficient, it was short. So it made sense to do it that way. On the other hand, I've been running quite a complex high-value oil and gas arbitration, and I can see some of my opposing counsel are actually on this call, some of the lawyers from there. And in that, when you do really heavy, document-heavy, complex infrastructure projects, it is to be able to have your expert evidence prepared right at the start. That might not be possible because you might not actually have all of the information. You might not have all the documents. And on top of that, a lot of those cases, actually, the success of resolving them depends upon the two experts being able to narrow the dispute for the parties. So you kind of need that entire phase of expert conferrals, experts boiling the actual delay or the technical issue down, so that by the time you get to the hearing stage, even though you're fighting about 10 things, the experts have actually done a joint statement where they kind of go, actually, we agree on all of this, we disagree on all of this. And sometimes that can take about 2 years to achieve. And you can't really have that before you actually commence the arbitration. So it really does become quite case specific in my experience.
Right. Thank you so much for that, Gitanjali. I think we may be able to go back to this issue in the Q&A session at the end. Now, to you, Deb, does ACICA have any resources that help the parties in commencing an arbitration? And can you please walk through those resources? Deb? I'm not sure if it's me or I'm not sure I can hear you very well.
Sorry, Guillermo. Can you hear me now?
Yes, perfect. And only one more technical issue. Can I please remind everyone else to mute their speaker, and also if you can pause your video, that would be great. So ideally, we would only have the panelists with the video and the speaker on. Thank you so much, everyone. Apologies there. Go ahead.
Thanks, Guillermo. As Gitanjali was saying, your first reference point is always your contractual clause and any of the rules that are referred to in it. The ACICA arbitration rules and expedited arbitration rules contain specific requirements for items that need to be included in your notice of arbitration. And it's very easy to work through those items and make sure that you have each of them in there. To provide some assistance in that regard, our Practice and Procedures Board has produced a sample notice of arbitration and a sample answer to notice of arbitration, both of which are available on the ACICA website to be downloaded. They have been designed to address each of the points that are required under the rules and to bring your attention to some additional things that you might consider when you're starting the process. So that's one thing that I would point people to. We are also shortly coming out with some guidance around this question of memorial style versus pleading style, which will give some further information to everyone on that. So I encourage you to keep an eye out for notifications from ACICA on that guidance and on the website. And the Secretariat is a great resource. I mean, that's essentially what we're there for. And I would always encourage parties to give us a call in advance of starting the process to talk through practical requirements. As Gitanjali said, the last thing you want is to be having a problem with your registration fee on the day of filing, or some of the other areas we see people come unstuck. Is notification of requirements to the other side. So under our rules, the claimant is required to send the notice of arbitration to the respondent, and they need to tell ACICA how they have done that and when they have done that. And that becomes a part of the question of when the arbitration has been commenced, because it is a requirement as part of your notice of arbitration to have notified the other side. Now, all rules will have notification requirements in them, and so you do need to have conferred with the other side, if you can, in advance, to say, will you accept service by email, so that you can let us know that they're accepting service by email. If that has not occurred, then you need to look at sending it by courier and making sure that you can provide us with some sort of evidence that you have sent your notice of arbitration to the other side. So those are just a few things that, if possible, it's worth just giving us a call, talking them through, if you can, a week or so before you think you're likely to file. Obviously, we're very happy to help on the day, and that is not an uncommon occurrence, but I would certainly encourage people to think about it a little bit ahead of time, and just make that phone call so that we can provide you with as much assistance as possible.
Absolutely. Thank you so much for those takeaways, Deb, and definitely encourage people to do reach out to ACICA, as Deb was explaining just now. Turning to the second section, the appointment of arbitrators, if I may turn to Rob. Rob, is the appointment of arbitrators an important step in the arbitration process, and why?
Thanks for the question, Guillermo. So, in short, the party's ability to appoint an arbitrator is one of the many benefits that arbitration has over general court litigation. So, as many of you might be aware, in the court system, the parties have no ability to choose their judge who will be hearing their case. It is essentially luck of the draw, whether you have a judge who might be sympathetic to a plaintiff party, or if you have a judge who either possesses or does not possess the relevant technical expertise in the subject matter of your dispute. That is all up to the luck of the draw as part of the court docket system. Arbitrations, on the other hand, is very much different. Parties have the ability to either agree on the arbitrator directly, or they could agree on the procedure for selecting the arbitrator. And this is beneficial for a number of respects, because it enables the parties to have the flexibility to choose the right arbitrator for the case that they're dealing with. So for instance, there could be particular legal nuances that require someone who is legally qualified in a particular jurisdiction, or the dispute might have some certain technical nuances that require an arbitrator who has qualifications from a particular industry. So whatever the key issues in dispute might be, the arbitration process allows the parties with that flexibility to discuss amongst themselves, to negotiate, and to agree a process for selecting the right arbitrator or arbitrators, recognizing that there is no one size fits all. So by way of a practical example, we have a case right now where we do need someone with technical expertise in terms of things like web design and e-commerce, and the process that the parties have agreed has enabled that to occur, whereas we wouldn't have the luxury of putting forward names of judges, for example, if this was a court litigation matter. So that's why appointing arbitrators is an important step in arbitrations.
Right, and how do you use that flexibility, Robert? What can parties do in order to tailor the process that you've been discussing now?
Yeah, of course. I mean, like, the parties can take a number of considerations into account when they decide who they should put forward to be the arbitrator. The three immediate considerations that I have in mind, and I'm sure there'll be many more that Gitanjali and Deb might have as well, but the three considerations I would suggest would be bearing in mind the importance of the IBA guidelines on conflicts of interest. That's the first point. The second point is do not be afraid to communicate with your prospective arbitrators and to conduct a bit of a beauty parade before you select the right person. And then the third consideration would be choose arbitrators who have previously acted as arbitrators, and preferably go for those arbitrators who have direct experience in the area of expertise that you're after, rather than choose arbitrators who have a good reputation alone without more. So just turning to each of these considerations one by one. Why are the IBA guidelines on conflicts of interest relevant? Well, the first and foremost point is these guidelines promote greater consistency, and they avoid unnecessary challenges to arbitrators. You've got a section of the IBA guidelines which sets out the practical application and a list of scenarios which may arise that could suggest justifiable doubts as to the arbitrator's impartiality and independence. And so you've got the red list, which, for example, include arbitrator's law firm currently has a significant relationship with one of the parties. You've got the orange list, which spells out certain situations that, depending on the facts, may give rise to justifiable doubts as to the arbitrator's impartiality or independence. And that could include, for example, where the arbitrator has, within the past, say, 3 years, been appointed on more than 3 occasions by the same counsel or the same law firm. And then finally, you have the green list, which sets out situations where there is actual conflict. And so there is no duty on the arbitrator to make a disclosure. Now, why is this relevant when you're choosing an arbitrator? Well, it would be a bit of an own goal if you were to put forward the name of an arbitrator to be either the chairperson or a sole arbitrator, where they would be triggering an orange or a red list. And in one of the recent examples that we've come across, the opposing counsel had nominated an arbitrator to be a chair, but that same arbitrator later disclosed that they are currently sitting in an arbitration involving that firm. And that fact was actually not known to our opposing counsel until post that disclosure. And that disclosure enabled us to at least put forward an objection on the basis that one of the scenarios could have been triggered and therefore raise justifiable doubts. And so the relevance of the IBA guidelines, in my view at least, is before you put forward the name of an arbitrator, be sure to check internally within your firm to find out whether any of the orange or red list scenarios might be triggered if you were to put forward the name of that arbitrator, because the last thing you want is to nominate someone, but to have that arbitrator give a disclosure that would fall within a red or orange list.
Right.
The second tip I've got is don't be afraid to communicate with your prospective arbitrator and to ask them to provide you with further information and their credentials. So, for example, if you've got to be involving issues specific to a particular industry, like construction or tech or whatever it is, don't be shy about asking the prospective arbitrator to give you their CV and for them to highlight in that CV any relevant experience they may have with tackling issues pertinent to that industry. And so that, I think, would allow you to compare different prospective arbitrators to then make the call, well, will this arbitrator be able to deal with that issue competently? Have they dealt with this before? And do they need a lot of hand-holding to even understand the basics of what we are fighting over? The other point I would suggest that you do as part of this credential process is to also ask the prospective arbitrator for their hourly rates and their remuneration terms. Because that is a factor where you've got 2 arbitrators with very similar experiences and very similar CVs. The fee that they would charge might be the deal breaker between the two, the tiebreaker rather, between the two, to then allow you to choose one over the other. So again, I would not be shy to communicate that with the arbitrators and to request that information. The third tip I would put forward is to choose arbitrators who have previously acted as arbitrators rather than counsel, because an arbitrator who actually has worked previously as an arbitrator would be able to, in my view, direct an arbitral timetable that would be streamlined, would be efficient, and would cut down costs for both parties. they would know from their experience what works and what doesn't. And so that would be, I think, the first thing I would suggest. The second point I would suggest is if you've got a dispute that requires a three arbitrator panel, then I would be wary about appointing 3 very reputable and very senior arbitrators. This is because very reputable and very popular arbitrators tend to be very busy as well. And so if you want to get a hearing date, it could be quite a struggle for all 3 reputable and popular arbitrators to find a date that would be an earlier point in time to what the parties would like. So I would rather suggest that you choose maybe for the chair to be the senior and highly reputable and highly experienced, rather than all 3 members to be of that kind of characteristic.
Thanks for that, Rob. Apologies for the interruption, but
forward as part of this observation.
Rob, apologies for the interruption, but I'm wondering what Gitanjali thinks about that. If you can maybe open the debate here.
Yeah,
what do you
definitely.
think?
Sorry, I'm just unmuting my. Thanks. I completely agree with all of Rob's points there. That the considerations he's raised are right. That you look for arbitrators that will be suited to your case in terms of their experience. You make sure that you yourself are not causing justifiable doubts and impartiality. On the chair point of choosing somebody senior, I think practically speaking, the reason people do that is you kind of want the chair to be the person who cajoles the group together. I'll take a step back. There is a presumption in arbitration that just because each party is choosing one arbitrator, that arbitrator is somehow their party arbitrator. Well, you may have chosen that arbitrator because you've done this beauty parade and you've gone, well, I think this arbitrator will be really good, so I'm going to appoint this arbitrator. But at the end of the day, that arbitrator is still sitting there as an independent arbitrator, and they wouldn't be being an arbitrator or getting these appointments if they were not independent and impartial. So while I agree that there's a level of flexibility in choosing who you appoint as your party arbitrator, you have to always keep in mind that does not mean that arbitrator is there to advocate your position. They are still independent and impartial and actually there to do the job right. Why it sometimes helps to have a senior chair is because it actually displaces that notion even more. So if you are going through a hearing and if, clients start going, it's usually clients will start going, oh, I thought our arbitrators should be saying our position, and you're trying to make them understand that's not how it works. Or it actually always helps to have a senior arbitrator where you can say to the client that, look, if the client is feeling that the other side's arbitrator is giving them a bit more of attention, you kind of say, look, you look at the chair will manage this. That is not how arbitration works. I don't think that is what is happening, but you're able to then use a senior chair that can cajole it together and bring the group more cohesively and actually it actually strengthens your perspective of not having, there not being an apparent bias in the party appointed arbitrators, if that makes sense. I say this, but I say this also feeling a bit bad because I do think that there is a bit of an issue in the arbitration world that the people who do get to be appointed are all usually too old, too senior, too busy. And when I say that you appoint someone senior, I don't mean that they need to be pale, stale, and male. Somebody who is actually quite experienced in their field also constitutes a senior, and parties should keep that in mind.
Absolutely. Any comments, Deb, on this?
No, I agree with what's been said. And in part of what we take into account when we're looking at appointments in terms of the next generation is the opportunity when ACICA is able to make an appointment for us to look at that next level in appropriate cases. So, if we have a case that comes in that may be is a fairly low value or a fairly straightforward case with not a great deal of complexity, it's one that we will certainly look at a younger and emerging arbitrator list for an appointment if it's an ACICA appointment that's being made. So I would certainly, and I was also just going to make the comment that we make an appointment in fairly rarely in the grand scheme of things, because our rules do provide very strongly for party autonomy in terms of appointments. So if it's a sole arbitrator, the parties are given the opportunity to agree that person. If it's a panel of 3, each party has a nominee, and those 2 nominees will make the appointment of the chair. And it's only if one of those steps falls away or is not taken that ACICA will step in and make an appointment. So we're not, we certainly don't make the appointment in the majority of our cases. But when we're given that opportunity, it's something that we look at quite carefully. And we will take into account all of the factors that Rob and Gitanjali have been talking about in terms of reaching that appointment. And availability is obviously of key concern. And we will look at that with respect to any requirement for expedition as well in a case, and how quickly a matter needs to be moved forward. And we'll look at it more generally in terms of longer term availability of arbitrators. And going into all of the mix of all of that is obviously contractual requirements for arbitrators. So that's perhaps a point for front-end lawyers to think about. You need to be a little bit careful in the drafting of dispute clauses with respect to, hard and fast requirements for an arbitrator, because that obviously narrows the available field at the time of appointment, and that may not actually be what you want at that point in time. And we'll look at contractual requirements. We look at submissions that the parties have put forward, and in some cases, there might be some real disagreement between the parties as to what the requirements are. So we often get comments from both sides, and we need to look at the dispute as a whole, all of the information that we've been provided about it, and to find the best person for that dispute.
Right. Thank you so much for that. Back to you, Rob. This brings me to my next question, and Deb's just touched upon this a little bit. Can you walk us through the process of appointing the chair of the tribunal or the president of the tribunal and the sole arbitrator as well? Because we've been mainly focusing on party-appointed arbitrators, and as Deb was just highlighting the role of ACICA, I think would be useful for everyone to summarize the process. Thank you so much.
Yeah, of course. Thanks very much for the question, Guillermo. So there's a number of ways you can go about to appoint the sole arbitrator or the chair, but one of the more common ways, from my experience, is the list procedure. But the list procedure, which I'll explain shortly, requires both parties to be reasonable and willing to engage in the process in good faith. Otherwise, it just won't work from a practical point of view. So what exactly is the list procedure, and how does it work in practice? There's, in my view, 2 ways you can do it. There will be more, but in my experience, there's 2 ways. The first way is the parties will exchange with each other a list of candidates. Each party then informs the other party of the candidates whom it accepts or rejects. The parties will then try to agree the right candidate based on the remaining candidates on the list. And if they can't do that, they will then defer that decision, like ACICA, to say, here's the residual list of all the candidates that haven't been rejected. Can you decide for us who should be chosen? So that's one way of doing it. The second way of doing it is the parties could invite the institution, like ACICA, and say, can you give us a list of potential candidates? The parties then strike out a certain number of candidates from the list and then rank the remaining candidates in order from best to worst. If there is a common candidate with the best ranking, then that candidate is chosen. If you've got 2 or more candidates with the same ranking, then the parties can try to agree who should be chosen. And if they can't, it goes to the institution to be picked. So, like I said before, list procedures work well if the parties engage in this process in good faith. But sometimes it doesn't necessarily happen in practice. So I had a matter recently where we agreed to do a joint list with the other side. We provided 3 names each, and we struck 1 name from each other's lists. We ended up with 2 names on each of our respective lists. The other side then challenged both of the remaining candidates on our lists for a number of what we think to be unmeritorious challenges. So, for example, one of our candidates on our list happened to be a former partner of our opponent's law firm 10 years ago before they retired from that law firm. So they said that's a big deal for them. They can't accept that. And then the second candidate was appointed by our firm 3 times in the last 4 years. And again, they said they don't like that. That raises justifiable doubts. So there were a number of instances like that whereby we said, well, if you're going to just go to the institution with a list that contains only your nominees and you're going to object to the remaining nominees from our list, then we'd rather just go to the institution and have this matter dealt with there. And so that's what happened. So the list procedure would work if there was mutual agreement and parties are both acting reasonably. But if you were to play tactical games, then it doesn't really work effectively in practice. Right. So that's the list procedure. The other way you could do it is the parties could simply negotiate with each other on who they could pick. But again, that's sort of like the list procedure as well. You do require a bit of reasonableness and engagement in the process in good faith. Otherwise, the matter should be dealt with by the institution and let them decide.
Right. Thank you so much for that, Rob. Let's turn to the third topic, challenges to arbitrators. And back to you, Gitanjali. What's the test to challenge an arbitrator?
I think Rob has already discussed this test at length. And the test, again, you find it in your rules, but it's pretty much common across all of the different arbitral institutions, and that's the justifiable doubt as to impartiality and independence. I know that the ICC rules have a bit of a different wording. It's the alleged lack of independence and impartiality, but essentially it comes down to being a case of, from a reasonable third-party standard, whether there is even apparent bias. There doesn't need to be actual bias, or in all circumstances. This is the test that gets bandied more, but of course, most of the rules also have a second part to challenging an arbitrator, which is if the arbitrator does not have the qualifications that the parties had agreed upon. So going back to Deb's point, when sometimes front-end lawyers get very creative and put in 20 characteristics that the arbitrator should have, an engineering degree and 3 years of experience trading currency, or all of that kind of stuff. And if you don't have those requirements, you could challenge the arbitrator on that basis that they don't have those characteristics. Now, on that justifiable doubt, Rob's also touched upon the IBA guidelines on conflict of interest. Generally, what happens is parties kind of look to those guidelines. They're by no way, you don't have to follow them, but they've become the guidelines that everybody looks at. That you look at them to go, okay, does this disclose? Does what I have found out about this arbitrator fall in any of these categories? And as Rob mentioned, there's the red list, which is non-waivable. So, for example, if the arbitrator had a direct financial interest in the outcome of the dispute, that cannot be waived. There is the waivable red list, i.e., say if their family had an interest. But generally, I would say you steer clear of anything that is in the red list. And then, of course, as Rob mentioned, there's the orange list about whether you've done anything for them in the past 3 years. And then there's the green list, say, for example, we're both members of ACICA. So you do go through that list. If you're being diligent as a party and not using it for dilatory tactics, as Rob mentioned, you will be good about your challenges, and you will actually look to see whether there is an apparent bias and take guidance from that list. One thing I did want to say is in most institutions, what happens is when the arbitrators accept their appointment, they do sign an independence and impartiality notice, and in that they make disclosures. So if there is anything that they think should be disclosed, they make disclosures. So if an arbitrator thinks that something falls into the orange list or into a waivable red list, arbitrators are likely to make a disclosure. I have noticed the recent trend actually is to over disclose. So I have had arbitrators recently who've even gone to the lengths of saying, and Ms. Bajaj and I are in the Chartered Institute of Arbitrators. Ms. Bajaj and I have written an article together 20 years ago. So arbitrators are mostly getting quite conscious of their need to disclose, and they do tend to disclose. And then, of course, when a disclosure like that is made, it is upon the parties, on the other party, to decide whether they do think that gives rise to a justifiable doubt and that they want to mount a challenge. I would recommend that if there was one judgment that people should go and read, it should probably be the Halliburton and Chubb Bermuda case, which is currently still waiting judgment, if I'm not mistaken, in the Supreme Court in the UK, which is about repeat appointment. And it's about repeat appointment of arbitrators when say, there's a whole number of arbitrations that are taking place because of one incident. So this is the Deepwater Horizon incident and the arbitrations that have flown from it. And a particular arbitrator has gotten appointed, I think, about 3 times. And that they were challenged, and that the challenge did not succeed in the first 2 instances. So basically, the court held that just because there are overlapping claims, but there's a different party on this other side, but one common party, yes, there could be apparent bias, but that's not essential. So you'll actually look to the case. In this case, there was also an issue that the arbitrator hadn't disclosed this, and the 2 courts that have already looked at it kind of looked at it and said, well, the non-disclosures are accidental. It's quite interesting, the Supreme Court case, because in the Supreme Court case, the LCIA actually intervened, and I think, Deb will correct me if I'm wrong, I think the ICC intervened as well, because both the LCIA and the ICC have said that there actually should be a very high degree of disclosures on arbitrators, and they should follow the gold standard on disclosure. And something like this, which is from the repeat cases from a same incident, there is actually a duty to disclose there. I don't think the judgment has come out in that, but it's an interesting development in this area.
Right. Thank you so much for that. Rob, perhaps because we've been discussing the green list, the orange list, and the red list, and we've been going over this in detail. But if you could focus, please, on the orange list for a little bit, and maybe give us 2 or 3 examples so everyone can understand exactly how the test works in practice. I think that would be very helpful.
No worries, Guillermo. You dropped out there for a second, but so was the question that you had, when would you challenge an arbitrator?
Well, I was more dealing towards the orange list, and if you could please explain a little bit, 2 or 3 either war stories or examples that you think would be informative. Thank you so much.
For sure. I mean, the orange list, in my view, is one of the areas where arbitrators tend to make a disclosure, and then the parties decide whether or not that gives rise to justifiable doubts. And that's usually the area where there's a fair bit of debate. So, for example, one of the cases that I dealt with recently, we put forward the arbitrator's name in 2020, and the arbitrator had said he was appointed by our firm 2 times in the last 3 years, but he had been appointed also by our firm in 2016, which was outside the 3-year time period. Now, we would consider that to be outside the orange list, because the orange list provides 3 within 3. Whereas the other side said, well, no, given we're talking about early 2020, 2016, yes, it's technically outside 3 years, but it still gives rise to justifiable doubts. And so after quite a fair bit of to and froing in communications, the matter was then decided by the institution that, look, we don't want to take the risk of putting forward and appointing a chairperson based on a nominee whose credentials have been challenged by both parties, as to whether or not they meet or don't meet the orange list disclosure, let's just go with someone else. So it's sort of like they put that into the too hard basket. So I guess my advice on that would be, if you were to put forward a name of someone as a nominee for an arbitrator, and you think you're on the cusp of an orange list disclosure, you're better off looking for someone who is well clear of it, just to avoid the to and froing, especially if you've got an opponent who is going to try and take every point to knock out your nominee.
Apologies for that. So thank you so much for that, Rob. I think it's a good time to go back to Deb and ask her what's the practice in ACICA. Do you receive many challenges, and what's the process, and how do you typically approach those challenges there?
Thanks, Guillermo. Challenges to arbitrators are actually, in our experience, fairly rare. I think I would agree with what Gitanjali said before, in that the practice that we're increasingly seeing is arbitrators are becoming very open and frank in their disclosures, and that allows for parties to deal with these issues potentially before appointment, or if it's an ACICA appointment, we require all arbitrators to sign a declaration of independence and impartiality, and a statement of their availability, and that's provided to the parties. At that stage, they can then deal with any challenges, and a new appointment can be made if need be at that time. The way that the rules work is that they provide the opportunity, firstly, for the other party, if one party makes a challenge, for the other party to agree to that challenge. The next step is that the arbitrator can resign. And in our experience, many arbitrators would prefer to step back at that point than expose the award to any issues of challenge or enforcement at a later stage. So most applications don't get as far as consideration by ACICA, but we have a protocol in place to deal with that. And in essence, the application goes through to a member of the ACICA Counsel, who independently looks at the case and all of the submissions that have been put by the parties. And they make a recommendation that goes to the ACICA executive for a determination, which is then issued to the parties. So I would agree with all of the comments that have been made so far about challenges. But yeah, in our experience, it's fairly rare.
Right. Any comments, Gitanjali, on your side?
No, I actually think that a lot of the times that challenges are made, they're not actually made formally. They're made between, and a lot of the examples that Rob has given as well, that they're made kind of between the parties to either delay or to get some other type of advantage, like get your own arbitrators on the list, or to delay the proceedings. I have a very, very similar example to Rob, where the challenge for an emergency arbitrator was only raised between the parties on the basis of saying, oh, by the way, did you know the emergency arbitrator that has been appointed was actually a partner in our law firm 10 years ago? It doesn't cause us a problem. I hope it doesn't cause you guys a problem. And it was done simply because there was knowledge that the other side's clients would not like that, and that would delay the process of the emergency arbitration, which, as you know, is called emergency because there is some emergency. So it's a good dilatory tactic there. One thing I was also going to say about what Rob was saying about the orange list, I think it goes on the basis of services and relationships. So whether you had previous services rendered or current services rendered, whether you have a relationship with the party, etc. On the previous and current services, this whole thing about whether you, in the previous services, is the repeat appointment issue, which is what I was talking about in the Halliburton case as well. But in the current services, it's actually quite complex sometimes, because a lot of the times arbitrators are still, but some arbitrators are still partners in law firms, and that would fall under the current services. So it could be that there's a case where an arbitrator is a partner in a law firm, and that law firm is providing services to an affiliate or to that party, but on something else. That's where it becomes a bit difficult. But what I see, mostly, unless you're using it as a dilatory tactic or you really have some reason, people are quite reasonable about it, because otherwise you would exclude quite a lot of arbitrator appointments on that basis.
Right. Thank you so much for that. I think we're seeing that the beginning of the arbitration is a very critical time period, right? Whether you are thinking about your notice of arbitration, your RFA, strategically about the case, strategically as well about your appointment of the arbitrator. So we only have, I'm conscious for time, we only have a couple of more minutes. But I was wondering if, like, as a final remarks, if each of you could focus on one or 2 points where you would advise young practitioners at the beginning of their career to focus when making sure that the team advising the client is, ahead of all the issues and making sure that the parties put in the best possible place to, one, appoint the best possible arbitrator, and two, also get it right in the RFA. So if I can start with you, maybe Rob.
Thanks, Guillermo. I mean, I've got sort of 2 points to raise if you were to start an arbitration and you want to get the process right. The first point really is read the agreement closely. Find out, what characteristics, if any, the parties have agreed for the purposes of appointing the arbitrator. Find out which rules the parties have agreed to arbitrate under, and what those rules say when it comes to commencing the arbitration or appointing arbitrators, just to be familiar with that, because you don't want to trip up on the process. The second advice I would give is be aware of the IBA guidelines on conflicts of interest. If you were to put forward the names of an arbitrator or arbitrators, make sure you do your homework within your firm to make sure that that particular nominee is not going to trip up on an orange or a red list factor, or if they were to trip up on an orange list factor, it is something which is more likely than not to be an issue. But I would try and stay clear out of orange and red list issues if I can. So those would be my 2 bits of advice.
Thank you so much, Rob. Gitanjali?
Thanks. Very similar to Rob. So Rob said read the agreement. I would also say read, as a junior lawyer, read every single page and every single word of the actual rules, the arbitral institution rules. I mean, we all know that the senior associate partner is just going to be looking at you on the last day if you don't have 3 copies or how many ever copies, or if you don't have the addresses as to where the respondents need to be notified. So, at every step in an arbitration, in particular at the start, make sure you know the actual procedure which is in the rules and know it by heart, so that you are able to say, okay, I need 10 copies. I mean, you can have an notice request for arbitration, which could be quite comprehensive. Say it's like 500 pages. And on the last day, you realize you actually needed 10 copies of it because there were, 9 respondents, and actually more than that, because you need 1 for the secretariat, 1 for, and you just haven't gotten around to organizing all of that. So I think that read the rules. And similar to the point on the arbitrators, I think a lot of the research into arbitrators is usually done by the junior practitioners. So you basically just have a partner go, okay, make me a list, do that homework really well, and not just for the purposes of so that your arbitrators don't get challenged or et cetera, et cetera. You will not believe how much clients love to blame the firm if despite you telling them a million times that just because we appointed a party appointed arbitrator, it does not mean that they need to have a disposition to your case. But there is a lot of that. So the more homework you've done, the more answerable you will be, or you'll make your partner to the clients.
Absolutely. Thank you so much, Gitanjali. What about you, Deb? Any final remarks?
Well, I suppose I would just reiterate what I said earlier about making sure that you call up the secretariat beforehand. We're a resource, and that's what we're intended for. So if there are questions about how the rules operate. You just want to make sure that you know that you have everything in order. That's what we want people to be calling us about, to make sure that we don't have those stress levels rising at the last minute. We've also put a lot of resources on the website. So we have a practice and procedures toolkit that has a number of resources. We have some external resources that we've tried to bring together a lot of the externally available resources that are put out by organisations like the Chartered Institute of Arbitrators. And going to Rob's earlier point, they have some notes about the interviewing of arbitrators that are quite a good resource if people have never before dealt with the process of speaking to an arbitrator before making an appointment. So have a look at the website and look through some of those resources as well, and just inform yourself so that, you know, as Gitanjali says, you're going to be the person that everyone looks to at the last minute, and make sure that you've placed yourself in the best possible position at that time.
Absolutely. Well, thank you so much, everyone, for joining. Especially thank you, Gitanjali and Rob and Deb. And obviously, anyone, if you have any questions, feel free to reach out to any of us. We'll be happy to have a chat with you or to interact more in detail. So thanks, everyone, for joining, and have a great day.
Thank you very much.
Thanks, everyone.
Thanks, everyone.